Just said, my name is Amanda Kay. I'm a program attorney at the National Council of Juvenile Family Court Judges. Today is the first in a three-part series on child custody for advocates. The idea for this webinar series came about because most domestic violence victims in family court do not have counsel, and there's not enough legal aid to go around, as we all know. So we thought it would be helpful if we could assist advocates in knowing what the resources are, getting a basic level of understanding of family court, and could help point their clients in the right direction when they are involved in custody cases, whether divorce or an unmarried custody case. Before we begin, just to get some idea of our audience, I'm going to ask the poll question be put up that just asks what your role is, what your profession is, and if you could click where you fall, and that just gives us some idea of who we're talking to. Okay. Great. Well, looks like we still have a few more coming in, but I think we got enough to have a good idea. Okay, great. Well, thank you so much for taking the poll. Today, in this first of the webinar series, we're calling it Beyond the Legalese, an Introduction to Family Court. The idea is to give a fairly brief overview when we get into all of the possible details that are available, but of what happens in family court, who the people are that your client will be interacting with and will need to be working with. And then Jenny, you want to introduce yourself?
Sure. This is Jenny Woodson. I'm the Family Court Enhancement Project Coordinator in Multnomah County Circuit Court in Portland, Oregon. I also was an advocate for about a little over 10 years, primarily focusing on civil legal advocacy with survivors.
Learning objectives. After this webinar, you will be better able to distinguish legal information from legal advice, state the purpose of family court, identify people and professionals in family court, define terms commonly used in family court, summarize legal standards frequently used in custody cases, list forms and other paperwork often required in family court, describe typical family court procedures, and explain ways to learn about your own local court. The key starting point for a non-lawyer trying to talk to a client about court matters is an understanding of legal information versus legal advice. Anybody who has legal information can share it. Legal advice, you need to be licensed as a lawyer, or a couple of jurisdictions are exploring other limited license possibilities. But so legal information is just knowledge. It's knowledge about the law, about court rules, about court procedures, any other specialized information that anybody can have. You know, you probably already have some just from your work as advocates. The court staff will have some, you know, the front desk clerks and other court staff. Legal advice is when somebody with that knowledge applies it to the facts of a particular case and gives advice to the client on what they should or should not do, or which option they should take. So, for example, if somebody asks, it's okay to say these are the forms for a custody case. This is the form for requesting an exemption from mediation. This is how you request a hearing. You have to call this person and ask for a hearing and give them a case number. You can tell what happens at certain points in a case. Legal advice is telling someone, this is the form you should use in your situation. This is what you should write on your form, and given the facts of your case. You should request an exemption, or you shouldn't request an exemption. You should ask for a hearing, or you shouldn't. That's when you cross the line into legal advice.
And I always think about I think that should and how are very important parts of the legal information or advocacy versus the legal advice. Looking at what the court can and can't do, I think a lot of these are pretty obvious, but the court can award custody and parenting time, make orders of support payments around spousal support or child support, look at dividing property and debt, grant protection orders, and then enforce orders through contempt when they're not followed. Things that the court can't do, making either party easier to get along with or helping one side get revenge. You can't force people to change their behaviors. And another important one is this considering information that's not properly presented. And as we go through, we're going to talk a little bit more about the rules and roles of different individuals in the court system. But one thing that was always very striking for me as an advocate, I would sit at these collaborative meetings with judicial officers, for example, and think, wow, they really know their stuff when it comes to domestic violence. They're very well informed. And then I would see them in court and think, wow, they just really missed this issue. But after talking to some of the judges and having formed more of a relationship with them, one of the things that the judges would say is that we can know something, we can know it in our gut what's actually going on, but unless there's very specific information that's properly presented following these rules of court and rules of evidence, they can't consider it. So keep that in mind when you're talking to clients that you're working with, and as you continue to observe court proceedings, that piece is really, really important. And then this last one that comes up frequently is having contact without notice to the other side, or ex-parte communication. When the judge talks to one side, they have to talk to the other, and they have to know what the other person is talking to the court about or what information the judge has had. There are some exceptions to this. For example, in our jurisdiction around protective orders, that initially is an ex parte proceeding where you can go and talk to the judge without the other party being there. But for most of your family law cases, that's going to be very limited.
Yeah, if the protection order is one of the very limited exceptions. Otherwise, unless it's like an exceptionally egregious emergency, the other side has to be notified, and both sides have to be there when you're talking to the judge. And then as far as the information properly presented, basically that's evidence rules. The court is not allowed to base a decision on stuff that it knows outside of what is presented to it during the hearing. And so it's up to the parties to present that evidence. We're having the second in this webinar series is specifically on that topic, so we're going to keep it very cursory today on that. But if you're interested, you can come to the second in the webinar series on April 18th and hear all about that.
Mm-hmm. So looking at some of the parties in the case, again, fairly obvious, but the judge is really the final decision maker, and they preside over the court hearings. The parties are the clients, your clients, their spouse and partner, petitioner, respondent, I think plaintiff. A lot of jurisdictions use different names. The clerk, there's usually the court clerks that file documents with, and then one that helps the judge in the courtroom. Law clerks that will do legal research and help write orders. Bailiff, the security at the courthouse. Sometimes they're just security officers. And again, I know in some jurisdictions they do many different things. Your court may have a self-help center or facilitator that will help litigants that don't have attorneys with paperwork and procedure. Mediators or early neutral evaluators. Most courts have some form of alternative dispute resolution, and it's often mandatory. There may be exceptions, particularly around mediation and domestic violence cases. There might be waivers. Maybe the mediators do shuttle mediation or something like that. And then other folks that may be involved in the case, maybe your court asks that the families undergo a custody evaluation. There may be guardian ad litem appointed to the children, or CASAs, the court-appointed special advocates for children, a children's attorney, some representative for the child that can evaluate the family and really look at the children's interest. And this varies greatly in jurisdictions and different levels of training that they have. They have different role definitions. Some are private paid practitioners, some are court employed, some will just volunteer, so there's a huge variety there.
And just, actually I'm going to go back for a second here. Oh no, that's okay. We characterize the judge as the final decision maker, and if the parties can't resolve it, that's true. Ultimately, it is the party's decision whether to enter into an agreement with the other side or submit it to the judge. So there is this level of control. The parties, usually it's either plaintiff and defendant or petitioner and respondent, depending on the jurisdiction. It can be, different courts call it different things. Law clerk's usually a recent law graduate, but some judges have career law clerks that stay there for a long time. As far as the ADR, alternative dispute resolution, there's a lot of different forms. There's two mentioned on the slide here, mediation and early neutral evaluation. There's collaborative law, there's arbitration, there's a settlement conference with the judge. There's a lot of possibilities, but mediation and early neutral evaluation seem to be the most common from the jurisdictions that we looked at. The custody evaluator usually has some type of graduate degree, at least a master's level, often a PhD in psychology or child development or something like that. A guardian ad litem will have quite a bit of training but may not have advanced degrees. CASA is usually a volunteer who may have some training. Some jurisdictions don't really have any training, or they may have extremely short, only 8 hours for everything that they want to cover. When they talk about different role definitions, some of these folks are there to make a recommendation based on the child's best interests. Some of them, particularly like a children's attorney, can be there to represent the child, and that may have some slight differences in whether they are advocating for the child's wishes, particularly depending on the age of the child, versus what they might view as the child's best interests. And that can be important to know when you're going through a case, you know, exactly what if any of these people are involved in a custody case, it's important to know what their role definition is, and it helps to know what their background is and what kind of training they might have.
And additionally, how they're getting their information, if it's all from interviews just with the children or with the parents, or for example, in custody evaluations, usually they're getting a lot of collateral information, or they're interviewing other practitioners and reviewing documents that have been submitted related to the children, talking to teachers, therapists, things like that.
Right, and some of them, particularly the first three, custody evaluator, GAL, and often the CASA, will also observe each parent with the children, usually on a very limited basis, maybe an hour or two tops, but trying to get some idea of how the children interact with the parents. It's generally a very artificial setting, and it can, particularly in the DV context, it can be difficult because when, you know, given how manipulative abusers often are, it's very common for them to put on a show for an evaluator in these positions and come across as the most wonderful parent ever. And some, particularly an evaluator who does not have good DV training and a good understanding of DV dynamics and batterer behavior, is not going to pick up on that. And that can be something to be aware of and watch for, and try and provide enough information, particularly for the ones that are getting collateral information. I mean, that is something to bring up, is the behavior may be different based on who's watching. Obviously, there's no way that we're going to get through an overview of family law in the time that we have. Plus, that's not really something that you as advocates need to know. More just where you can find it and where you can find help. Family law is state. It's governed by the states. There's very, very, very little that comes from the federal government that has anything to do with family law. So what that means is each state is going to be different. And there are some commonalities and some concepts that are pretty much the same in every state, but it plays out in so many different ways depending on what jurisdiction you're in, what state you're in. Also, local practice can make a difference. I know in my state, we've got 2 big cities and then a bunch of rural areas, and each city does it differently, and then the rurals do it differently again. So that can be really important to know for your clients, is kind of the local practice and the local culture of your family court. The 2 main sources of family law are statutes, which are, what most people think of as laws. They're bills passed by the legislature, signed by the governor, and they are the basic starting point, and it's the first place to look. It does, unless a statute's unconstitutional, then it does control what happens in the case. But in the American system, we also have what's called case law or precedent, and it's pretty common to have, you'll have a statute that says something, and it seems clear when the legislature passed it, they thought it was going to work, but then when it got applied to a particular family in a particular case, it got confusing. And so the court will say, okay, here's the statute, here's this family, here's how we're going to apply it in this family. And that then becomes a rule of law that applies in other cases, particularly if it's an appellate court, like the state Supreme Court or the state Court of Appeals. And those are rules, unless the legislature overrides them. Those are rules of law the same way that a statute is, and will be followed by other courts. These can be really difficult for a non-lawyer to figure out. That's basically what law school does, is train you how to read cases and pull the rules of law from them. So the important point for advocates is you're probably going to need help if there's this type of rules in your jurisdiction. And most states have at least 1 or 2 in the family law area. It could be something about how the best interest factors get applied. It can be something about how child support is determined. It can be something about how you decide whether a custody arrangement is really joint custody or not. But it is something to be aware of, because those rules can be, they're much harder to find out about. We'll probably need to talk to a lawyer about it, and we'll talk a little bit more about that, how you can build relationships that can help you with these situations. Just briefly mention constitutions. Every state has their own constitution, and then there's the federal constitution. That's always the highest legal authority, but it very rarely comes up in family court, because usually it's not constitutional interests at stake. Once in a while, you might have a due process issue, and there is a Supreme Court case that recognizes the rights of parents as a fundamental legal right and entitled to constitutional protection. So once in a while you will see some constitutional stuff, but that's very rare in family court. The other type of law or rule to be aware of is court rules. They mostly govern procedure. They'll say, you know, this is how you start a case, this is how you serve it and how long you have to serve it. These are rules for how we're going to govern the court proceeding. These are rules saying when you have to go to mediation or other alternative dispute resolution. Sometimes there'll be rules about other requirements that have to be met. So those all are part of the picture as well. And then legal standards, we didn't, because these are really specific to particular jurisdictions, we didn't try and come up with a huge comprehensive description of everything that might come up, but these are kind of just some basic concepts that arise in pretty much every court, and then some specific to family court, that kind of you'll hear the words used and will hopefully give you some idea of what they mean and what the idea is behind them. Jurisdiction is used a lot when it's used in relation to a court. It's talking about the power of the court to hear and decide a case. That includes power over the parties. In family court, usually jurisdiction over the parties is based on where they live. If you live in a state and you've lived there for at least some period of time, 6 weeks, 3 months, then the family court in that state will have jurisdiction over your divorce or custody case. Standard of proof, you know, I think most people, lay people, think about you know, beyond a reasonable doubt, which is the standard in criminal cases. In family court, it's lower. It's the specific term is preponderance of the evidence. That just means more likely than not. If you had to try and put a number on it, it's like whatever one thing over 50% is, that's preponderance. Some states will require what they call clear and convincing evidence for certain things. For example, the state that I'm located in, you have to show domestic violence by clear and convincing evidence to get take advantage of certain custody presumptions. That is a higher standard. It's not as high as beyond a reasonable doubt, but it's higher than preponderance, or you know, that kind of more likely than not. You have to take it to another level. The problem is there's not really good descriptions of what that means. It's basically whatever the judge decides convinces him or her, which sometimes isn't all that helpful. The burden of proof just says you start with the way things are now, and if somebody's asking to have that change, usually they've got the burden to show why that change should happen. You know, why what they're asking for is appropriate, is in the best interest of the children, is fair. So that person will have a little bit more work to do when it comes to the court. We've already used the term best interest of the child a few times here today, and I'm sure most of you have already heard it. It's a phrase that gets used a lot, even just in non-legal contexts. It is the most common standard in the U.S. for determining custody and deciding on parenting plans. I'm off the top of my head, I can't think of a state that doesn't have it in some form. Each state usually has a list of factors to be considered in deciding whether something's in the best interest of the children. Some will also have overarching policies. They'll have, for example, you know, they might have a statute that says, oh, the overarching concern in family court is the safety of the children and the parents. Often there's one that, and it's nice when a state has that, because that can be very helpful when there's domestic violence present, because you can always, regardless of the rest of the factors, you can always go back and argue safety. For a lot of states, if there's a policy statement in the statutes, it'll be something like the policy of this state is to encourage relationships between children and both parents. And so that will come up and as you're trying to make arguments about custody. Presumption, I used that word a little bit ago. Presumption is basically a rule that applies if certain conditions are met. So the one that comes up most often where domestic violence is present and you're talking about a custody case is somewhere around 35 or so states have a presumption that if domestic violence is shown, the abuser should not get custody of the children. And so once you show domestic violence, that rule is triggered, and the presumption is that the victim parent should get custody. These presumptions are rebuttable, which means that depending on other evidence in the case, the judge may decide, even with that presumption, all this other evidence indicates I shouldn't apply it and award custody differently. The other type of standards that come up, and these I'm just going to touch on really briefly. Child support guidelines. Most states have some formula that applies to figure out what child support is going to be, often based on the parents' incomes. Sometimes also taking into account the time that the children spend with each parent. So just to kind of be aware that they're out there. And then in divorces, you have equal or equitable distribution of the property. Basically just when this doesn't apply in unmarried cases, but it would be an issue in a divorce case. And just to kind of be aware of that your client may be dealing with that. We're not going to get into any details on that today.
And I'm sure you all can see where this is complicated as we talk about things like the best interests of the child and standards that a state may have in addition to the presumptions around safety and domestic violence, that sometimes it feels like those are contradictory, that the parents are encouraging a positive relationship with the other parent, yet, you know, you have a survivor who may be perceived as not doing those types of things because they're worried about the safety. And so I think in a lot of family court situations, we definitely see where that gets tricky for survivors.
Okay.
So when thinking about how to get more information about the law, definitely doing some research, looking at websites, local, state resources. Often legal aid offices have materials that are specifically designed for litigants themselves as opposed to creating something for attorneys. Self-help centers in the courthouse often have some specific, state-specific information. And then womenslaw.org is just a good resource that's organized by state, particularly if some folks have questions about other states that you're less familiar with, if they've recently moved or thinking about moving. And then building a relationship with your local legal aid office or a local attorney. Sometimes they do have hotlines, and sometimes as you're working together, they'll be very open to answering non-case specific questions, some of those hypotheticals. And that can be really helpful when you just need a piece of information to pass on. And same thing about making those relationships with your local court and court staff, having someone there that you feel comfortable just saying, so, you know, hypothetically in this situation, and again, not asking for legal advice or them to, you know, guide your client on what to do or not to do, but really just to get those pieces of information that you might not be familiar with yourself.
And one thing that didn't get on the slide, but if you have a law library where you are, they can also be really helpful, particularly about things like finding the statute that apply for your client or court rules. The librarians usually there will be a lawyer on staff, but not all the staff will be lawyers, but they do know how to research, and they do know what materials they have, and they can be really, really helpful. They're not everywhere, but if you do have one where you are, that's definitely a good source to look for.
And also, if there's a law school in your area, oftentimes there may be clinics that the students run, either to help with representation, but also, again, maybe some questions as you go along. So usually the first step for someone as they're starting their family law case is to start doing some paperwork. If you've seen the forms for your jurisdiction and what those are like, usually there's a lot of paperwork. In Portland and Multnomah County, our forms are maybe 60 pages of instructions plus another probably 50 or so pages of actual forms to fill out. And they usually start with a complaint or a petition. That's what's starting the case, and this is where you're asking for what you want, and you're telling the court what the facts are, and then what that relief that you're looking for from the court, or what you want to have happen. The other party has a chance to respond to that paperwork, either in an answer or response, to say that they agree with it, they disagree with it, and then then we have the counterclaim that they want to ask for something else, or the relief that the other party specifically wants to ask for. And when thinking about paperwork with working on paperwork with survivors, I think this is another really important advocacy role in just helping folks sort through that. And again, not telling them, remember our legal advocacy or legal information, legal advice slide that we were talking about this, but we're not telling people what to fill out in their forms, but sometimes just helping people sort through them. Oh, it looks like here's another space where really you're just writing your name again, or I know this is the address portion, or let's read through this together and see if we can puzzle it out together. Thinking about what we know about how people are impacted by trauma and how hard it is to sort of think linearly when we have these court processes and court forms that really expect people to do things very specifically according to specific rules that have a lot of this legalese in there that we've been talking about. Most people are not familiar with it. And I always tell people it has nothing to do with how smart you are or anything like that. It's just confusing when it's not the language and the world that you're living in every day. When you start talking to court staff and lawyers, sometimes they make it seem like this is the easiest thing in the world, but it's also something that they look at day in and day out. Some jurisdictions are doing paperwork a little differently. There's been a lot of movement to help, especially in family court self-represented litigants, because we know so many family court cases, there aren't attorneys on the case. In our jurisdictions, about 85% of the folks that file do not have an attorney, at least one party. So that's a lot of lay people trying to figure out how to go through these processes. And so courts are definitely looking at this and trying to simplify paperwork and simplify instructions. But it's still challenging, and you have to follow all these. You have to follow these statutes, legal rules, and things like that. So hopefully some forms are getting simpler over time, but also some jurisdictions are trying to do guide and file or e-court, e-file. We use a product here called TurboCourt, which is just like it sounds, like TurboTax, where it's an online interview and then it fills out the forms for you. Some courts just have PDFs that are fillable forms. So there are some other options that are popping up that hopefully can just make this paperwork more accessible to people. Mm-hmm. We didn't talk about the motion, but this is just asking the court to do something specific. And again, the other side can oppose this. the order is the court's decision or directions to the parties. So this is what must be followed, or you can be held in contempt. And then often it might be called a final judgment, or in a divorce decree, but it's the end of the case. It's, instructing the parties what they are requested to do by the courts. And then, of course, in each jurisdiction, you're going to have other forms and documents that are going to be needed to initiate and finish a case.
Yeah. There's, just going to jump back for a second. In between the complaint and the answer it's not another paper exactly, but what happens once the complaint or petition is filed is it needs to be served on the other party. That's something that usually is done by the sheriff's office, or some places other people can do it. There's also a lot of states have licensed processors that you can do it, but they charge. And that has to happen before the rest of the case goes forward. If you don't serve the complaint or petition, then the case will probably get dismissed and won't move forward. And then if you do get service and the other side doesn't file an answer or a response, then you can just submit the judgment you want. And you say it's called taking a default, and it says, okay, I filed my complaint, I've served it, it's been the time that the rule says the other side has to respond, they haven't filed anything, they haven't asked for more time, so I'd like to enter default and have the judgment that I want. And you submit, more paperwork. There's forms to get the default, and then you have to submit the judgment or the order you want. If the petitioner or the plaintiff is unrepresented, the court might want to talk to the person first, or might just go ahead and say, okay, the other side didn't bother to show up, you get what you asked for. And then just under these other forms and documents, the fee waiver can be really important. A lot of victims are having have financial issues. They're trying to reestablish a separate household. Often there's employment issues. Usually they're financially disadvantaged in comparison to their soon-to-be ex-partner. And so there are, again, another form to be filed, but this one can be really worth it. If you request to have the fees waived, and sometimes it's just called a fee waiver, and sometimes they get you with the Latin, and it's called in forma pauperis. But it's just a little form that you fill out, attach a financial form that says what your income is, and that will waive the filing fee. And really important for the service, it waives the service fee. If you don't have a fee waiver, you need to pay the sheriff or the constable or a process server to serve it. If you have the fee waiver, then service by the sheriff is covered. And that can be a big deal, I mean, even just in addition to the filing fee. Court-related proceedings. This is just kind of the shorthand term that we're using to cover things that happen during the case but are not actual hearings before the judge. Some states have what's called an early conference or an early case conference, and this usually is with the judge, and it just is the parties and the judge, and then if there's attorneys get together, the judge will ask some questions about the case, might ask how long they think it'll be to get to trial, ask if you think there's any possibility of reaching an agreement, at least on some issues, if not the whole case. Often we'll ask, is there any, do you need a temporary custody or child support order to govern during the course of the case until we get to the final hearing and final judgment, and we'll set temporary visitation terms or temporary child support. Can also include other things like temporary spousal support if it's a divorce case. Other things that a lot of jurisdictions have is requirements for certain classes. A common one is parenting after divorce or parenting through divorce, trying to educate the parties a little bit and get them thinking about how they're going to co-parent after a divorce when you're living in separate households. A lot of these classes don't really talk about what it's like to co-parent with after an abusive relationship ends. That doesn't get you out of taking the class, but it means that it may not be that helpful to you. Also, some places have workshops for self-represented litigants. Only one jurisdiction that I'm aware of off the top of my head, it's required for all self-represented litigants to take this class about what to do in court. But a lot of other jurisdictions do have them. It's good to be aware if they're available because those can be incredibly helpful if your client's representing themselves in court. Evaluations all fall under this category, and we've spent some time talking about those already as far as the different types. And then the alternative dispute resolution methods. There's, like I said, mediation is probably the most common, but you'll also hear early neutral evaluation, which the model that I'm most familiar with, it's the parties go in and meet with two neutral evaluators and basically get some understanding of where their case is and what they can expect to happen in court. Collaborative law is kind of a newer model. I personally am not that familiar with it, but it is kind of starting to spread slowly. It's in a few states. If it is something that you have in your state, I would suggest seeing if you can build a relationship with a lawyer, either a legal aid lawyer or maybe a private attorney that is interested in pro bono and might be willing to give you a little bit of guidance on what's involved in that. Some places will have settlement conferences with the judge or with a settlement conference official of some kind. Often it's basically mediation with a different label. Sometimes there can be a little bit different tweaks. Big thing to be aware of in a lot of jurisdictions, particularly the alternative dispute resolution is mandatory, but there's an exception if there's been domestic violence, either to get completely exempt from the requirement or to get modifications in the protocol that's followed. Jenny was talking about earlier, there might be mandatory mediation, but if there's been violence in the relationship, you can ask for a different protocol and they'll do shuttle mediation or something like that. You can also ask, sometimes there's a way, like if classes are required, you can ask that it be required that you go to separate classes so that you're not in the same classroom with the batterer. In the evaluation setting, usually the evaluator is interviewing each party separately, but once in a while there might be a situation where an evaluator normally would talk to both parents together, maybe to start the proceedings. If that would be a safety concern or just a bad idea generally, then often there's a way to request an exemption for that. And even if there's not specifically a form for it, that's when you can go back to that piece of paper, the motion. Anytime you want to ask for something, you can file a motion and you just explain what you want and why. And then it'll be up to the judge. If you're addressing the request to somebody like a mediator or a custody evaluator, you might be able to just do that by a letter or even just a phone call and say, there's been violence in the relationship. I'm concerned about what we're going to have to do through this process. If they're well trained, then they should be doing some type of an orientation with you, but not everybody is, and so sometimes it helps to know that you can ask for things even if they're not offered. And so if there's a protection that you want, or you're worried about, am I going to have to be in the same room with this person, and are you aware of this background? I'd like some safeguards to be taken, and you can always ask for those.
And a lot of as we're going through this, it might be clear, but a lot of the processes and the approach in family court is this underlying assumption that the parties can get along at some level and work together, especially when there's child custody involved, that both parties are there for the best interest of the children and can sort of negotiate and meet in the middle. And we know a lot of that goes sort of out the window, and we're thinking about domestic violence. And not that survivors can't do some sort of agreement or settlement before they get to a hearing or going to a trial on the case, but oftentimes the cases that do end up in trial are because there's some domestic violence, and a lot of these the alternative dispute resolution and mediation and things like that aren't going to work because of the power differential between the survivor and their abuser. And so, I think another reassuring thing that you can, as advocates, provide for survivors that you're working with that are going through this process is sort of talking about that expectation. A lot of the things that are required are really not a good fit for families in domestic violence. I think Amanda mentioned the parenting after divorce class is a perfect example. I know in the class we offer locally, it's a 3-hour class, about 10 minutes, they say, if you have some safety concerns, this might not work. But then you have to sit through the rest, nearly 3 hours of the class talking about how you just need to get along with the other parent for the best interests of the kids and how that might look. So sometimes just providing that reassurance to your clients that, that they're not feeling crazy about this process, that it really is set up to do that, and that it just is going to look different for them if they have some safety concerns. And particularly if they're not in a position or decide that they don't want to talk about the domestic violence in the court case. So if you do have a hearing, again, sometimes there might be some hearings that before an actual trial where the judge hears about each side and makes the decision about what's going to happen. But anytime there's a hearing, it's really just an opportunity for the court to hear from the parties and their witnesses, take evidence, and often they do announce a decision by the end of that case. Sometimes they leave and think about it and then notify the parties of their decision. Sometimes there are hearings that are interim relief while the case is pending, maybe a temporary custody order before the final order is decided. Courts really anticipate that a lot of things are going to be settled outside of the courtroom, and so judge time is often hard to get, and definitely hard to get quickly. So sometimes folks do have to wait, and those temporary orders might be important there.
Yeah. Okay. I use the word etiquette because it really kind of sums up. It's not anything that's specifically in the rules. It's just customs on how court usually happens, and how people usually behave and what order things are done in. Often there are little quirks depending on the judge. A judge may like things done a certain way. A lot of them are to show respect for the court and the process. And some of them, it's like once you're familiar with it, it's an efficient way of proceeding. So for the judge, for the lawyers, they're used to it. They know where to put pieces of information because they know where it fits in the whole scheme. For those who are not familiar with it, it can be a little bit baffling. And it's really hard to try to put into this webinar or even just to describe for somebody all the little things, because once you're used to doing it that way, you don't really think about it. So you'll see when we get to some suggestions for things you can do later. One is try to go observe an actual court hearing. That can be the best way to get a feel for all of these little unspoken customs that occur during court that nobody really thinks to mention because it's just the way we do it. You know, some of them are easy to distill, and I mentioned them here. You know, you stand when the judge enters. Usually the bailiff will say, "All rise," and everybody does, and then the judge will say, "Please be seated," and then move on. Whenever you talk to the judge, you're supposed to stand up, unless the judge specifically tells you you don't have to. You can call the judge Your Honor or Judge. A big thing is don't interrupt the judge. Almost all of them absolutely hate that. You know, that doesn't mean once they're done, you don't make your point. But it usually is better not to interrupt them. And then the seating, I'm going to go ahead and go to the next slide here. I did a little graphic of what this looks like. So this is kind of a typical courtroom, and I don't know what happened to the T's got cut off there. Sorry about that. I thought I fixed that, but the judge is usually in the middle, often raised above floor level. And you'll see I've made the desk kind of big. That's usually because I've got a lot of stuff up there. These days they'll have a computer up there. They'll have the court file, often if there's a paper file. And so it gives them some room to be around. Unless your court was specifically designed to be a family court, there will probably be a jury box that's not used in family court because there is no juries in family court. But if you're in just a regular typical courtroom, it will be there. Then there's a place for the witness to be, and then the court clerk kind of oversees the paperwork. Sometimes I didn't put it on here because these days most of the time if there is a recording or reporting being done, it's electronic and there's not a separate person. But sometimes if it's an old-fashioned court reporter, there might be also a court reporter kind of next to the court clerk. There'll be a table for the defendant respondent and then a table for the plaintiff petitioner. Usually there's a sign on the tables that tell you which table your client should go to. And then there's what's called the bar. It's usually a low rail or fence, some kind of barrier, and then some seating behind that for anybody who's there just to watch. Sometimes witnesses who are waiting to be called will be there. Sometimes the judge has them go wait out in the hall so they don't hear what's going on in the case and have their testimony influenced by whatever's happening before they talk. And the bailiff I've kind of put there, but they are often moving around the room. So that just kind of gives you some idea of what to expect. And again, take a visit to your local courthouse, and that'll be the best indication of how the courtrooms in your location are set up.
And be prepared to talk to your clients about this kind of setup. And, you know, start by asking, have you been to court before? What's your experience in the courthouse? You know, you'll find that folks have worries from getting through security, accessibility, parking, what to wear. You know, a lot of times we make a lot of assumptions about what people should or shouldn't do. You know, for example, in, you know, having seen other courts across the country, I know, at least out in Oregon, we're pretty casual when you come into our court. I mean, attorneys and such are usually, you know, in their suits, but a lot of times other folks that are in the courtroom are not that dressed up, but if you're on the East Coast, it might be folks are very buttoned up, and the litigants are expected to, have a tie and, be wearing certain things. So just all of that local information that you can provide to help eliminate that nervousness for your clients going into court, because so often they're really worried about what's going to actually happen. So the less they have to worry about some of those other things, suggesting they do a dry run and they come to court, they park, they see how long it takes. They see how long it takes to get through security. Maybe suggest that they don't, go through a metal detector and have to take off their shoes. So maybe they don't wear really intricate laces or, just whatever it is that will help people feel at ease, and ways that they can feel supported and safe in the courtroom. So if it's not a common practice for your court to have security or a bailiff in a family courtroom, can you request that one is there for their hearing? Helping people know where to look if in case their abusers trying to stare them down, just anything that will help folks feel better prepared when they get into the courtroom can be really important. So you checking out hearings and starting to understand some of that etiquette and local practice can really help offer some relief to your clients as they prepare to go to court.
Just another quick note on the security piece. Depending on what they might typically have in their pockets or in their purse, might want to suggest leaving some of it at home. I've had situations where clients, are trying to come through security and, there wasn't, particularly if it's something valuable, because usually security can hold it for you, but if you don't want to leave it with them, sometimes there's not really a secure place. They just kind of have it, where the officers sit. So the best thing is just to, if you possibly can, either leave it in the car or leave it at home so that it's just not even an issue and you can just breeze through security, depending on how long the line is, without having to deal with emptying your pockets or your purse while you're trying to get in there and get your mind set for a court hearing. And then court hearings themselves, I mention opening statements just because they can be used. It's very much up to local practice. I will say it's usually more common in jury cases where the jury is coming in and doesn't know anything about the case until the trial starts. In family court, usually the judge has already at least read the file, even if there hasn't been a prior hearing, and so knows what the allegations are, knows what each party asked for, at least in their papers, has some level of understanding of the case, so they don't really need an opening statement per se, but it could be that local practice is even in a family case, and even if the parties are self-represented, an opening statement is typically used. So that's one question for either when you go, either if you can do an observation or if you can get a local attorney buddy to ask some of these questions of, that's one thing that you could ask them. And then each side gets to tell their case. Any witnesses they have, usually they're going to talk themselves as well. And usually that's most of what they present is their own testimony, but there might be other witnesses. Ones that can be important are anybody that observed anything to do with the violence, people that observed either of the parents with the children. You usually won't be able to get anybody from a school to come, but sometimes that could be, or if there was a related child protection proceeding, again, they usually won't come, but sometimes those could be things to explore. If the party or the children have a therapist, sometimes you might want them to come. testify. So any of those people. Generally what happens is, the witness testifies, the other side can ask questions, and then the judge can ask questions as well, trying to clarify things. Then once the plaintiff or petitioner is done, then the other side gets to go. And then if you remember back earlier, I was talking about the person who's asking for something, the plaintiff or the petitioner, usually has the burden of proof. Because of that, they get a chance to respond to the other side's opposition. So they'll get what's called their rebuttal. So if the other side presents something that is wrong, your client would have the opportunity to come back and say, no, that's wrong, and here's why, and here's what the actual story is. Again, on closing arguments, these are more often used in family court than opening statements are, but they may or may not be required for a self-represented party. It's kind of just a way to sum up the facts in your favor and make a last pitch asking for what you want. It just kind of summarizes for the judge what you think are the most important things for him to consider, or her, and then what you'd like the judge to do for you. And that can be helpful because it helps to focus the judge. And then the judge may have questions even during closing argument, just kind of to clarify what the relief is that you're asking for. And it's not uncommon for it even to be, well, you might be asking for one thing and the judge might not be willing to go that far, and so we'll say, well, if I'm not willing to do that, how would this go? And we'll ask for feedback on, if I don't want to order this type of custody arrangement, but I do understand your concerns with safety or with overnights, how would this visitation plan or parenting plan work? And ask for your input on what happens with that. And not every judge will do that, but if you get one that does, that shows that they're a little bit concerned, and it gives you another opportunity to, or your clients another opportunity to have some input into what the final arrangement's going to be. Okay. I think we both, there we go. Jenny, do you want to start, or? Most family court cases are settled. Often it can be, and often a lot of them are settled even before, in the grand scheme of family court cases, a lot of them are settled before they even get to court. A lot of jurisdictions have what's called a joint petition, where the parties work everything out beforehand, fill out a form that says, here's everything that we want, both sign it, submit it, and they'll have their divorce decree in a matter of, maybe a few weeks. That's great when it can happen. That's pretty rare that that's the case for somebody who has a violent relationship in their background. And if that does happen when there's been violence, it's usually not a good agreement. Other times you might be able to reach an agreement on certain issues. For example, you might be able to say, okay, we'll each keep our cars, and one party gets the house, but they won't be able to decide on a parenting plan arrangement. It can be done at any time. You can, like I said, you can do it before the case is even filed and just submit a stipulated, an agreed judgment. It can be done through some of the alternative dispute resolution proceedings that we talked about, mediation or any of the others. It can happen in the middle of trial. For example, a witness gets up and, the testimony is really impactful. It really is important and changes the game, and sometimes, you'll realize, okay, you know what, I think we need to reach an agreement because that pretty much took care of it. And then even after trial, it can be settled. If the judge hasn't actually issued the decision, it's not too late to settle. But as always, in all of these frameworks, the caution for cases with domestic violence is the power imbalance, particularly when the victim is unrepresented, because there's nobody there to advocate for them, to provide support. And this one is certainly there, an advocate can provide moral support, but depending on the context that any of these negotiations happen in, the advocate may not be able to be there. And particularly if the victim has decided they don't want to bring up domestic violence, and so they didn't seek, for example, they didn't seek an exemption from the mediation requirement, then they may be in there on their own, and it can be very easy to get a lopsided agreement. One of the other things that the National Council does is try and train judges to recognize when there's been a domestic violence in the relationship and when an agreement probably should be looked at a little bit harder to be sure that it's going to be safe and fair. But not every judge goes to our trainings, and sometimes there's not enough information in the case to tell that there was domestic violence in the background. And so there's only so much that anybody besides the party can do, but certainly provide support and provide caution, encourage the client to seek any protections that are available so that the power imbalance isn't determinative, that there's a way to negotiate from a more equal standing in somehow, or to get, if we're talking about an ADR process, just get exempt from that. Jenny, you got anything to add on that?
No, and I apologize, everyone. I had accidentally muted myself.
Oh. Okay. Next step is once there's been a final order, then the expectation of the court certainly is that this is the end of the case. Go forth and follow my order, and ye shall be happy. And it doesn't always happen that way. Sometimes enforcement is needed. The most typical way is through the court's contempt power, which basically is something that the court has just because it's a court. It has the authority to enforce its orders, and it can do that by way of contempt sanctions like fines. It can do it by way of putting somebody in jail until they do what they're supposed to do. Sometimes there are other enforcement mechanisms. For example, some statutes allow for other types of sanctions to be used, or other types of kind of consequences to encourage compliance with the order. For example, in the parenting plan context, the judge may say, if certain parenting plan provisions aren't filed, then you're going to see a change in the parenting plan that favors the other party. Sometimes there will be statutory remedies like fines, or in the child support context, sometimes they can order wage withholding right up front. Sometimes if it wasn't ordered right away, but then they don't pay it, you can ask for that to be ordered, and so the support just gets paid right out of the paycheck.
And I'd say one thing to think about with the enforcement is that it often falls on the petitioner or one of the parties to enforce it, that the court's, not really going to know what's going on unless someone comes to court and says that there's a problem. So, this is one way, too, that batters will take advantage of sort of the complexity of the system, in that they'll try a lot of things to see what they can get away with, because it's either these little infractions from the batter, and the survivor might be feeling like, I don't want to get into this whole court thing again. So I definitely see a lot of situations where batters are just pushing. I think we have this idea that once the parties split up, everything is just over with, and especially, again, when their children are involved, they're going to be probably connected for a number of years, and, sometimes we see batters take advantage of that over time.
Yeah, and unfortunately that is very typical, and one thing that can be done up front a little bit is try to ask the judge for an order that is as specific as possible and tries to cover contingencies as much as possible. That's not a guarantee that there won't be either a situation that wasn't contemplated, or that a batterer who's smart and manipulative won't be able to find some loophole, but it at least can cut down on it if the parenting plan is very specific about what the times are, what the exchange situation is going to be, what happens if somebody's late, what happens if somebody misses their visitation, what happens if somebody wants to reschedule, how that communication is to go, and what happens if the parties don't agree. One thing that can be good to ask for is just to, and also things like makeup visitation. If somebody misses a visit, is there going to be makeup visitation, and if so, who has discretion or final say on what form and when that will happen? Those are things that you can ask for in the judgment itself to try and cut down on some of the chipping away that a batter might try to do after the judgment's entered. I've never heard of a way to totally prevent it if that's how the batter wants to play it.
And I think for folks to think in advance what it's going to be like working with their ex, around, I think a lot of times folks are trying to get away from the person. They think that maybe appeasing them or giving them what they want will help with safety, and sometimes that's definitely true. But again, for those, sometimes in the parenting plans, it might be sort of vague about notification if someone's late, or as Amanda was describing, what happens when you miss time and things like that, and just that talking to survivors to think about how has it been trying to negotiate and work with your partner before, and really thinking about, should you ask for that negotiation to be part of how issues are resolved in the future. And oftentimes, survivors really think about that. They know that they're not going to be able to just work it out as issues arise, and so the more specificity around all those potential things can really help with safety in the future.
Okay. And then just kind of Jenny mentioned, if you've got children, then you're going to be involved with this person, no matter how much you wish you weren't, until at least the youngest child is 18. And that's how long the custody order will remain in place. And just real quickly, I see a question about if a couple with children are not married, is the court process the same? Usually it will be called something different because a divorce, and a divorce will have other issues because a divorce involves terminating a legal relationship, the married relationship, as well as dividing any property and debt. And it's possible there might be a few other considerations that might be in a divorce case. But the custody laws and most of the procedure around to the children for custody and child support will be the same regardless of whether it's married or unmarried. Specific states may have some differences in some of the statutes, but most of the concepts will be the same. The best interest of the child and related standards will be the same. So
I would just say,
I was just going to say the only other difference often is where the parties start from. In most states, if the parents are married, then the starting point is for the court is that they each have equal custody and equal rights to the child, and neither side can prevent the other from having any contact with the child and having time with the child, and at least until there's an actual order entered. For unmarried parents, it depends. This one can be more state-specific. Some jurisdictions, there is a presumption that the mother has custody unless there's an order that says otherwise. Other jurisdictions will use the same starting point as for married parents. Each parent has, as long as there's been an acknowledgement of paternity or a finding of paternity, each parent has equal rights to the child. So that's something that might be specific to your state.
Well, I was just going to add a lot of the assumptions in family court and the conversations we've had here today are assuming opposite gendered parents. And I think just thinking about if you're working with survivors in same-sex relationships, that there might be some extra considerations, and particularly as local family laws catch up to federal marriage provisions and things like that. So, oftentimes there are attorneys in the area that might be looking at some of these issues more specifically. So it might be harder to, in a lot of cases, for someone to find an attorney, but in a case like that, there might be some, maybe doing some advocacy to help them find a family law attorney that looks specifically with family law issues and with same-sex couples might be helpful. And there might be a little more opportunity there for some pro bono representation or free representation. So I know we've sort of left that out in our conversations today.
Yeah.
But it could definitely add a lot more complications for a family.
Yeah, especially because a lot of states, like Jenny was saying, the law has not caught up to reality. You'll find a lot of states whose statutes still, talk in terms of mother and father only, and do not contemplate any situation where there might be, two mothers or two fathers, and may even say that you can't have that situation, that there can be only one mother and one father. And obviously that is stuff that's going to need to change, but that's going to be slow, particularly in some jurisdictions. So anyway, going back to modification, because this, this can be a very long-term order, things can change. People's lives change, things can happen to people, things can happen to the children that might change how a parenting plan needs to go. It can also be that the other parenting plan, it just turns out isn't working, and things have happened. The two primary ways to modify, if there can be an agreement about what the modification is, then you can submit a written stipulation to the judge and just ask the judge to sign off on it. If there isn't agreement, then, kind of going back to that motion, and if you want to ask the court for something, then you do it through filing a motion, and you file a motion to modify. Usually, once the final judgment's been entered, the court will require what's called changed circumstances. You have to show that the situation of the parties and the children has changed since the final judgment was entered, and that's why a new order is needed. It can't just be that you're not happy that you didn't get the order you wanted the first time. That's not a basis for a motion to modify. But if the situation has changed, somebody's work hours changed, somebody had to relocate, it turned out that a child has special needs, and so changes need to be made to the parenting plan to accommodate that. Those types of things are for when you file a motion to modify based on changed circumstances. It can also be that, or at least it might be worth arguing, is if the original order turned out to be dangerous, and something happened that caused safety concerns, that can be a reason to go back and ask for modifications. The best thing is to learn your court. So, go ahead, Jenny.
Yep, definitely. I was just going to say the same thing. Definitely learning what your court has to offer and what local processes are, and building those relationships either through any coordinated community response, multidisciplinary teams, any working groups that your family court may have. It's very common that on the criminal side, there's a lot of the CCRs, but definitely looking for any of those that are looking at the family court, just so you have a resource for your information. And I think, we won't go into a lot of the recaps. I think we have a few questions, but
yeah, I agree.
I think this number one thing about being realistic about the expectations, I think just helping survivors manage expectations of what they're going to get from the court is so important. Just about what the court can and can't do, just how difficult it might be, how emotionally difficult it may be to go through this process, just as much as you can help them manage those expectations and support them through the process with information, or if you can go to court with them as a support person, things like that can be really important.
And just real quick, going back to the getting to know your court, in addition to building the relationship with the court staff and court-related professionals, and we kind of put this a little bit earlier, but also your local legal aid office, they can kind of be your go-to source if they're willing for any questions about the family court process and the law. You might even be able to ask if either somebody from the legal aid or maybe a local attorney with family law expertise is willing to come and do a short presentation for your domestic violence program advocates, and kind of give you, maybe an hour on what you should know about local practice and local customs. That could be incredibly helpful, and it's not much of their time, and you might find that would be something they'd find very worthwhile. Like Jenny said, I think recap, you'll be able to, you can download the PDF of the PowerPoint, so you've got all of this information there if you want to go over it. I think we'll take a quick look at any questions. I'm just going to add one quick thing. If you look down at that materials box below where your PowerPoint is, you'll see 2 other documents listed there, 10 steps for presenting evidence and 10 ways to find help. Those are some self-help resources that we developed that may be useful to you, to your clients. We're in the process of adding to this series. What we presented today will be one of the next installments. And so a lot of the stuff that is in the PowerPoint and that we talked about today will be in a short publication that should be out probably in about 4 to 6 weeks. It will be available on the Resource Center website, which is in the next box over under web links. That's the RCDV CPC link. If you want to bookmark that, you can go back and check in about 4 to 6 weeks to see about if the new resource is out.
I can start with a couple of the questions. When we were talking about the ex parte contact earlier, oftentimes the exception is with protective orders, no contact orders, orders of protection. All the jurisdictions may call them something different, but sometimes there's an exception for things that offer emergency relief. But then typically there's still a hearing or an opportunity for a hearing with the respondent or defendant at a later point.
Yeah.
And then depending on your,
I was going to say, for it to meet the standard for ex parte, usually has to be like extremely serious. Like you have information that he's got a gun and he's going to go to the school after the kids, or he got the kids' passports and he's going to try and take them out of the country. Something like that. I mean, it can't just be that, there's a disagreement about who's going to take the kids at a particular time. It has to rise to a level of actual danger to either the party or the children.
One of the questions about representation for custody cases, it really just depends on locally what resources there are. I mean, there are some family law clinics. Legal Aid sometimes offers free representation in family law cases. There might be some pro bono attorneys in your area that offers some free representation, but it really just depends on local resources, I would say.
Yeah, and there are a lot of legal aid programs do have a domestic violence practice, but in most places it's has a lot fewer resources than there are customers. So it's certainly worth trying for, because if you can get it, it can be an immense help to your clients, but you kind of need to have a backup plan.
And it looks like there are a number of questions about children not wanting to go to visitation related to fear of or concern about safety with the other parent. I think that frequently happens, and I think as children get older, and again, it depends on your jurisdiction. At least I know in my jurisdiction that, as children get older, I don't think the courts necessarily expect you to wrestle a teenager into the car and drive them to a visitation kind of thing, right? But if you have pretty small children, I've definitely seen the custodial parents facing some sort of consequence for not taking a child to visitation. And, I think there's probably a lot more discussion that could be had about supporting children that are anxious about going to visitation that we just don't have time to get into right now. But, I think any time that a parent is violating a court order, the baseline is that there could be some consequences. And, I think local practice will determine how serious those consequences are. And again, as long as parents know that there are some consequences when they make those decisions about, some parents might still decide, I don't care if I get him to court, I'm worried enough about my child that I'm not going to force them to do something. But ultimately, there could be some consequence. And usually that's where the modification and things like that might come into place, that if it's just so hard and difficult to get the child to go to visitation, or they're so concerned or so anxious about it, then that might fall on the safe parent to look at modifying the order.
Okay. Just real quick, I see a question asking for clarification of what I said about emergency dangerous situations. I wasn't saying that there would be separate hearings. I could say that possibly, if there was an emergency that couldn't wait for a full hearing, or if you could demonstrate that there was a danger to letting the other side know that you were asking for the court's intervention, that might be one of the very limited situations where you could go to the judge without the other side present and ask for what's called ex parte relief, where it's only one side being heard from. It doesn't mean that there would be separate hearings. What would probably happen is you would go in, if you can persuade the judge that there is this danger, you get the order and you get the children. Usually what will happen is once the children are safe, the court will let the other side respond and have a hearing to flesh out all of the rest of the facts. Let's see. And a quick question about supervised visitation. If you, Unfortunately, there's been reduced funding in a lot of places for that. If you have a DV-informed supervised visitation center in your area, that is always something to ask for if you've got concerns about the children's safety or the victim's safety during exchanges. Unfortunately, there's just not that's not available in a lot of areas.
And then I was just going to add there is a formal way to ask someone to be a witness, and that's usually through a subpoena. And in family law cases, usually, again, if you're self-represented, you have to either write one or if your court has a form for that. And then, as far as who can testify in the way that the court needs to know ahead of time, again, there are probably rules and local rules that will determine what the court needs to know, sometimes providing a list of witnesses or at least knowing how many witnesses to determine how long to set the hearing, things like that.
Yeah.
And then the question about how to testify.
Sorry, Jenny. That's stuff that's going to be covered in the next webinar, so if you can make it on April 18th or look at the recording afterwards, that should be in the next webinar. And we're way over time, so I'm afraid we got to go. Thank you so much for coming, and really appreciate the great response.